Does Florida's loser pay process work even if my case isn't frivolous? I think most people would agree that if a frivolous lawsuit is lost at a trial, that the other person should have to pay the attorney's fees of the person they sued. Kind of an easy call. And if you listen to politicians talk, they think that every case is a frivolous lawsuit if you lose. And that's just not the case. It's just not true at all. But in Florida, we have a system where under two conditions, you can be ordered to pay the other person's attorney's fees and costs. The first will be you sue someone for negligence. You go all the way to a jury trial. The jury returns a verdict saying they weren't negligent. They were not at fault. In that situation, you lost. You can be ordered to pay their attorney's fees and costs. If they make an offer to settle and the jury gives you a verdict that you win, they are at fault, but they don't give you enough money to come within a certain percentage of what they offered to settle with you before the verdict, you can be ordered to pay their attorney's fees in that situation as well. I am very careful with every client to make sure when we file a lawsuit that we're going to do our very best to never put a client in that position, that everyone understands exactly how the system works. We give it to you in writing so there's no misunderstanding about it. And we're going to do our very best to make sure it doesn't happen to anybody.